settlement from litigation. There is a statement to be read by GCA LP, and that was approved by the judge, and an appropriate response also approved by the judge. So with that, GCA representative, Mr. Fardo.
Thank you, Mr. President, members of council, citizens of Hampton Township, good evening. My name is attorney Noah Fardo. I've had the pleasure of representing Gladys Auld and her family and the company known as GCA. This is the statement of GCA. To the citizens of Hampton Township, some of you may know that GCA was involved in litigation against Hampton Township in a series of lawsuits that started way back in 2008. Many people have seen what occurred at the intersection of Route 8 and Duncan Avenue. The township took the old property by eminent domain, and now a big hole sits where their family office buildings once stood. Many longtime residents of Hampton Township understand and appreciate what that property meant to the Auld family. As citizens of Hampton Township, we all have an interest in open and honest government. Government that respects the rights of individuals and property owners. And government that will simply not disregard the law when the law does not suit its purposes. GCA filed a lawsuit in 2009 against Hampton Township, as well as its individual council members, Victor Sun, Peter Russ, Martha Hunkel, Michael O'Rourke, and Carrie Montgomery, and its borough manager, Christopher Lochner. The suit alleges that these defendants repeatedly violated the Pennsylvania Sunshine Act. And in the simplest sense, we brought this lawsuit because we believed that the Aulds family civil rights were violated. Really, our lawsuit has always been about two things: transparency and accountability. In our complaint, we have alleged that Hampton's officials met in secret to devise the Lower Allison Park Improvement Project. We believe Hampton took great care to avoid publicly using the phrase eminent domain. The defendants admitted deliberating the taking of the Auld property in closed executive sessions in June and September of 2009. Discussions, we alleged, were illegal under the law. We allege that Hampton's officials repeatedly violated the Sunshine Act by holding executive sessions without telling the public why they were holding their closed-door meetings. We allege that while the stated purposes for the taking the property was flood mitigation, that the officials had little or no evidence that taking the property would mitigate flooding in any meaningful way. They took it anyway. Even if the township officials honestly believed in their grandiose Lower Allison Park Improvement Project, we believe that there was no reason for them to take the Auld property when they did. The township took the property in year 1 of a 10-year plan, before necessary studies or permitting were complete, and years before any construction was ever planned. Is it possible that other projects, for example, the dredging of North Park Lake, would have obviated the need for further flood control on Pine Creek? What we do know is that 6 years later, there is no 8-acre lake on Pine Creek as planned. No dam is planned. No park is planned. The only thing there at the intersection of Route 8 and Duncan is a gaping hole where their buildings once stood. We believe that flood mitigation was a pretext, and the defendants took the property for a different reason, because the defendants thought it an eyesore, whereas Victor's son testified under oath, in his opinion, it looked like a piece of SHIT. GCA has settled its lawsuit against Hampton and its officials. The public should know that the township has paid the old $75,000 to settle their claims. This is separate from and additional to court adjudicated compensation for the property itself. We do not know how much the township has paid in legal bills to defend their conduct. Another condition of the settlement is that this letter be read on the record at a public council meeting and incorporated into their minutes. The people of Hampton Township deserve transparency, deserve a government that respects private property and individual rights, and deserves representatives that actually follow the law. Personally, we're somewhat relieved that this lawsuit has settled, that our year-long battle with Hampton Township is at an end. We are glad that some of what Hampton's leaders have done has come to light. We do not know how much this conduct has cost the taxpayers of Hampton Township. We can only hope that this marks the beginning, not the end, of a process that will ensure openness in government and serve as a reminder that government exists to help people and not to take advantage of them. Thank you.
Okay, as the judge also pointed out, as part of the settlement, we were allowed to respond. This is the judge-approved response. The Township of Hampton council members, both past and present, controller and township staff respect the right of GCA LP to express their distorted perception of the litigation that has languished since 2008. The undeniable fact is that the only action initiated by the township was an eminent domain proceeding precipitated by the unreasonable demand of GCA LP to be paid in excess of $6 million of taxpayer money for their property located within a floodplain that laid idle, vacant, and in disrepair for over 10 years as the property went in and out of bankruptcy and bank ownership. In response to the outright rejection of that demand, GCA LP embarked upon a series of legal actions against the township in which the township was forced to spend thousands of tax dollars to defend. The township was successful in defending all of those actions. Subsequent to a realistically, judicially determined fair market value adjudication of the eminent domain case in an amount exceeding $600,000, GCA LP, after accepting payment, continued in the pursuit of more money. These actions were driven by two underlying objectives: more money and political motivations to impugn the reputations of council members and staff. Allegations of demand for transparency and accountability were merely an attempt to secure additional money and damage reputations. Nothing more, nothing less. Logic would dictate that there is no gain to be derived by the township, as GCA would have you believe. There are no nefarious conspiracy. The only party who stood to gain in all of these actions was GCA LP. Inappropriately, GCA LP has done its worst to impugn the good reputation of individual council members and the staff of the township. As most residents should be aware at this point, the former GCA LP property located at the corner of Duncan Avenue and Route 8 is in the initial phase of an acclaimed flood and highway master plan for the area developed by Hampton engineers in cooperation with state and federal officials in an effort to mitigate flood damage. The design of the project has been overwhelmingly embraced by Hampton residents, Commonwealth and federal legislators, federal and state environmental agencies, and surrounding communities, especially those downstream. Using a stream of funding creatively established with various local, county, state, and federal sources, we are happy to say that the first phase of the project is well underway. We are hopeful that the additional grants and funding will allow the scope of the entire project to be completed over the span of a number of years. Currently, the establishment of the dry basin and highway improvement project is proceeding. The dry basin, which currently has a confluence of waterways bisecting it, will be surrounded by a walking track and encompass green space that will be able to be filled during a flood event. The highway improvement project includes a new expanded culvert replacing the deteriorated and dangerous bridge on Duncan, as well as the creation of turning lanes in both directions on Route 8, a turning lane on Duncan, and a park and ride south of the BP. The installation of the turning lanes on Route 8 will substantially improve one of the most dangerous intersections in Hampton. With the continued cooperation of PennDOT, we expect the project to be completed in 2015. While we are confident that the township would ultimately prevail on the remaining legal action, which was financially motivated and unrelated to the eminent domain case, the projected cost for defense, as litigation dragged on for years, would have cost the taxpayers of Hampton more to defend. We felt it was unfair to the residents to counter GCA's charade for years and consequently settle for a sum that was significantly less than the cost of defense going forward. The settlement puts an end to the public demonstration equivalent to a temper tantrum and allows the township staff and council to concentrate on the important continued success of ongoing operations of the township. Okay, item B, the manager